Welcome to the deep dive. So here's a question. What if discrimination isn't always, obvious? What if it's not just about one person being malicious, but something sneakier, something baked right into the systems we live in, and it just keeps going, even when nobody means for it to?
Exactly. And that's what we're really going to unpack today. It's a crucial topic.
It really is. We're moving beyond those simple definitions to get at the complex, often really subtle ways discrimination actually works.
hmm And to do that, we've pulled together some really powerful sources. We're looking at legal analysis from post-apartheid South Africa, which is fascinating. We've got reports on the UK's hostile environment policies, very revealing stuff, and also key case law from the European Court of Human Rights. It gives us a really solid grounding.
Right. The goal here is to give you, our listener, a clearer lens, a way to identify, understand, and importantly, talk about these persistent, often hidden mechanisms of inequality.
It's about equipping you with the tools, the insights to see what's really going on.
Yeah, think of this as your shortcut, helping you move past just feeling frustrated and towards, clear, sharp analysis. So let's dive in. When most of us think discrimination, we picture something pretty direct, don't we?
Usually, yeah.
Like someone being explicitly told no job, no flat, no service because of their race or gender or religion. It feels intentional, obvious bias.
That's the common understanding, definitely. That's what we call direct discrimination.
But what about when it's more subtle?
Yeah.
Woven into policies that look totally neutral, right? On the surface, they seem fair to everyone.
Now you're getting to the heart of it. That's where the legal idea of indirect discrimination becomes so important. The European Court of Human Rights, the ECtHR, they've done a lot of work clarifying this. So direct discrimination, like you said, is straightforward. Treating someone worse because of a protected characteristic, race, sex, language, whatever, it's explicit.
Okay, got it. That's the one we tend to spot more easily. But indirect discrimination, that sounds like where things get complicated and maybe where a lot of the systemic stuff hides. How do we define that?
Well, indirect discrimination is where it gets really interesting, precisely because it's not about obvious intent. It's about the impact. It's when you have a rule or a policy or even just a common practice that seems neutral. It applies the same way to everyone on paper. But in reality, it puts people who share a particular protected characteristic at a distinct disadvantage compared to others.
Okay. So the effect is unequal, even if the rule itself looks fair.
Exactly. Unless, and this is the crucial bit, unless that policy can be objectively justified. It needs a legitimate aim, and the means used have to be appropriate and necessary to achieve that aim.
So there's a justification test.
Right. And it really boils down to three key things you look for. First, is there an apparently neutral policy, measure, or rule? Second, does it actually create disproportionately prejudicial effects for a specific group? Does it hit them harder? And third, this is important, the policy wasn't specifically aimed at that group. It wasn't designed to hurt them, but it does anyway because of how it interacts with their circumstances. Okay, let me see if I've got this. A policy might be designed for a perfectly good reason, like, say, managing a budget or keeping standards up. But if the way it works ends up disproportionately harming a protected group, like people of a certain race or gender, it's still discriminatory. We have to look past the intent to the actual result.
Precisely. You've hit the nail on the head. It forces us to examine the real-world consequences, the lived reality, not just the stated goals. And, the ECtHR's thinking on this has actually evolved quite a bit. Before around 2005, they didn't focus on indirect discrimination that much. But since then, largely influenced by EU law, they've applied it much more robustly.
Why the change? What prompted that shift?
Well, there was this emerging international consensus, particularly within the Council of Europe. A growing recognition of the special needs of minorities and the duty states have to protect their identity, their way of life, really, to preserve cultural diversity. It's an understanding that just banning explicit discrimination isn't enough. You also have to tackle the systemic barriers, the things that indirectly keep people down. That makes a lot of sense, especially that link to cultural diversity. It feels like a deeper understanding of equality. Can you give us some real-world examples, cases that show this in action? It helps make it less abstract.
Absolutely. Let's look at a few from the Atinsky source. They really illustrate it well. Take Hogendijk v. the Netherlands from 2005. This involves a social insurance scheme for incapacity benefits. The benefits were tied to having earned income from work beforehand.
Okay, sounds neutral enough. Earning income from work.
Right. It wasn't explicitly based on sex, But because of historical employment patterns in the Netherlands, many married women hadn't been in paid work during the relevant period. So this neutral rule disproportionately affected them. We're talking about 3,300 women impacted versus only 1,800 men. A clear difference.
Wow. So the history, the social context, interacted with the neutral rule to create an unequal outcome.
Exactly. Now, in that specific case, the court actually found the policy was justified because of budgetary limits. But the example itself is powerful. It shows how a neutral policy, designed maybe for fiscal reasons, can still have a discriminatory impact if it doesn't account for those background realities.
Okay, so intent isn't the main driver there, it's the effect. What about situations where it's not even a specific policy, but maybe just how things are done, or even inaction?
Great question. That leads us straight to Opuz v. Turkey, 2009. This was about domestic violence. The court found there was judicial passivity, basically. The authorities weren't effectively protecting victims. And even if this inaction wasn't intended to discriminate, it primarily affected women. They call it a general and discriminatory judicial passivity, albeit unintentional. It's a prime example of a de facto situation, something that exists in practice, not necessarily by law, leading to indirect discrimination.
So the failure to act, the system's lack of response, becomes discriminatory in its effect. That's quite profound. What isn't done can be as bad as what is.
Precisely. It highlights systemic failures.
Any other cases that show this de facto aspect, where the practice, not just the rule on paper, creates the problem?
Yeah, Zarbadami v. Malta from 2006 is another good one. This was about jury lists. The criteria for being on a list, age, residence, language, skills, seemed totally neutral. Fair enough. Seems standard.
Yet in practice, men ended up outnumbering women on the lists by 3-to-1, a massive imbalance. And the court specifically said that discrimination may result not only from a legislative measure, but also from a de facto situation. The way the neutral rules were applied or how they interacted with society led to a discriminatory outcome in jury representation.
These examples really open your eyes, don't they? It forces you to look beyond the surface, beyond the stated rules to the actual outcomes. What about cases that dig even deeper, where the disadvantage seems baked into the very structure of, say, public services? For a really powerful example of that, we need to look at DH and Others v. Czech Republic 2007. This one is quite stark. The Czech Republic had special schools for children identified as having mental deficiencies, alongside regular primary schools.
Okay, special education provision. Seems reasonable on the face of it.
Exactly. Legally neutral, designed, presumably, to offer tailored support. But the reality on the ground was shocking. Evidence showed that back in 1999 in some of these special schools, 80 to 90% of the students were Roma children.
80 to 90%. That's hugely disproportionate. Why?
They were being placed there often because of real or perceived language and cultural differences. And critically, the psychological tests used to assess them. They did not take Romani specifics into consideration. The system essentially failed to account for the special needs of Roma children as members of a disadvantaged class. It channeled them into these separate schools based on culturally biased assessments.
So, the neutral system, by failing to understand or adapt to cultural context, effectively segregated Roma children, even without anyone necessarily having malicious intent.
Precisely. It's a classic and tragic example of how systemic, unintentional practices can create profound, lasting inequality. The system itself, through its supposed neutrality, became the instrument of disadvantage.
It locked them into a separate path.
Yes, and the ECtHR built on this in other cases too, like Orosha and Others v. Croatia in 2010 and Sampanis et Ultrasi Grace in 2008. These also involved Roma children being put into separate classes, often justified by saying they had insufficient knowledge of a language of teaching.
Language proficiency, again, sounds like a neutral criterion.
It can be. But in these cases, the effect was exclusively on Roma children. It wasn't just disproportionate. It was almost entirely impacting one group. This raises serious questions. Is it just disproportionate, or is it actually exclusive, pointing to something deeply systemic and the human cost? A psychological study mentioned in the context of these cases found significant emotional and psychological harm and lower self-esteem among Roma children in segregated classes. It's devastating.
So even something seemingly practical like language ability can become a tool for discrimination if the system isn't incredibly careful about how it's applied and the specific impact on vulnerable groups, it really puts the responsibility on the system to be actively fair.
It absolutely does. And the legal framework supports that shift in responsibility. The burden of proof is key. Once a difference in treatment and unequal impact is shown, it's up to the government to justify it. They have to prove the policy is legitimate and necessary.
And how do you show that unequal impact?
Often, statistics are enough to make a prima facie case enough evidence to get the ball rolling. This is vital because it acknowledges that the effects are what matter, not just the intentions someone claims they had.
Focusing on the effect, using stats, that feels like a really important practical approach. Why is this extra vigilance, this focus on effect, especially critical when we're talking about race?
Well, the ECtHR explicitly calls racial discrimination particularly invidious, something especially hateful and harmful. They say it requires special vigilance and a vigorous reaction from authorities. The reasoning is that racism fundamentally undermines democracy's vision of a diverse society. Authorities, they argue, must use all available means to combat racism, seeing diversity not as a threat, but as a source of richness. So indirect racial discrimination isn't just a minor issue. It's seen as a serious attack on fundamental rights and societal health.
Okay, that takes us deeper. We've covered direct discrimination and indirect discrimination, where neutral rules have bad effects. But what about when inequality gets so deeply embedded that it just persists? Even after the original discriminatory intent is long gone, it becomes almost locked in.
Now you're touching on something really profound. This is where Daria Roithmer's concept of the market lock-in model of discrimination becomes incredibly insightful. It uses ideas from economics, actually, to explain how discrimination can become structurally embedded, almost self-perpetuating. She talks about locked-in inequality.
Market lock-in. Like how Microsoft Windows dominated PCs for years. How does that relate to discrimination? Seems like a bit of a leap.
It might seem like a leap, but the analogy is powerful. Think about Windows. Got an early advantage, right? Maybe it was first, maybe it had good marketing. Then a feedback loop starts. Software developers want the biggest audience, so they write for Windows. Consumers want the most software, so they buy Windows.
Right, it feeds itself. More users mean more software, which means more users.
Exactly. It becomes self-reinforcing. Windows dominance gets locked in. Even if other operating systems come along that might be technically better, it's incredibly hard to displace the leader because everyone's invested in the existing system. The market is stuck.
Okay, I see the economic analogy. So how does Roithmer apply that to race or social inequality? An early advantage for one group just keeps reinforcing itself.
Precisely. She argues that a racial group's early monopoly advantage can become self-reinforcing and ultimately locked in. Think about historical contexts, like in the U.S., where white communities for centuries had privileged access to jobs, education, housing, wealth accumulation. That initial, often violently enforced advantage creates feedback loops. Access to better schools leads to better jobs, which leads to more wealth, which allows access to better housing in areas with better schools. And the cycle repeats and reinforces itself across generations. Inequality persists almost automatically, even if explicit discrimination lessens, because the structure itself is locked into reproducing that original advantage.
Wow. That reframes how you think about persistent inequality. It's not necessarily about constant ongoing discrimination, but about the inertia of past discrimination. So what are the key things that cause this lock-in? What makes these patterns so hard to break?
Roithmer highlights three core concepts that work together. First, and crucially, high switching costs. These are the massive costs, economic, political, social, that an institution or society would face if it tried to switch from a discriminatory practice, even an unintentionally discriminatory one, to a more inclusive one.
Costs of changing the system.
Yes. These costs can be so daunting, so prohibitive, that even people or institutions genuinely wanting equality find it too risky or too difficult to make the change. Roithmer used law school admissions as an example in earlier work. Think about the LSAT, the standardized test. There's evidence it disproportionately screens out applicants of color. But why do schools keep using it? Because the perceived cost of dropping it is huge. Maybe their rankings in U.S. News & World Report drop, which is their reputation, applications, graduate job prospects, alumni donations.
So the fear of losing status and resources locks in a potentially biased tool, even if they know it's flawed. The switching cost is too high. Okay, what's the second element?
Second is positive feedback or self-reinforcing advantage. This is that snowball effect we talked about. An initial advantage doesn't just stay static, it compounds over time, it gathers momentum. The group or sister that starts ahead gets further and further ahead, making it incredibly difficult for others to catch up. In the LSAT example, higher-ranked schools attract students with high LSATs, which boosts their rank, attracting more high scorers. The system validates itself, making the criteria harder and harder to question or dismantle.
Okay, high switching costs, positive feedback loops, and the third.
The third is path dependence. This is the idea that where you end up is heavily influenced by where you started. Early historical events, decisions, and structures cast a very long shadow. It makes it really hard to deviate from a path once you're on it, especially if that path was established under discriminatory conditions. Again, with the LSAT, Roithmeier points out these tests emerged when excluding people of color from professions like law was common practice. Some standardized tests were even developed specifically to justify exclusion. Given that history, that initial path set by racial exclusion, the lock-in model suggests that the early advantage gained by whites became self-reinforcing and is now embedded in the very definition of merit used by these institutions. Breaking free from that historical trajectory is incredibly difficult.
Okay, this is a really compelling framework. High switching costs, positive feedback, path dependence, all locking inequality in place. Let's apply it. You mentioned post-apartheid South Africa as a key case study for Roithmeier. That sounds like a perfect, if tragic, illustration.
It really is.
Yeah.
She uses the example of school fees in post-apartheid South Africa to show locked-in discrimination in stark relief. You have this paradox. South Africa's constitution guarantees the right to basic education, guarantees equality. Fantastic principles. Yet in reality, poor black learners are still massively disadvantaged, often excluded from better-resourced public schools because of mandatory user fees. Many historically white schools, conveniently located in the wealthiest areas now, charge fees maybe are $10,000 a year, which is around $530 US. That's completely out of reach for most black families.
So despite the end of apartheid, the fee system effectively reproduces the old racial and class divides in education.
Exactly. It creates a deeply segregated and unequal system, even though there's supposedly an exemption process for poor families.
Now, the obvious question. The new, black-majority ANC government, elected on a platform of equality, kept this system that reproduces apartheid-era inequality. Why? Was it hidden intent, after all?
That's the crucial point Roithmeier makes. She argues it wasn't intentional discrimination by the new government. Instead, they were trapped by those prohibitive switching costs. They inherited a system so locked in that changing it fundamentally seemed impossible without risking catastrophe.
What were the choices they faced, and how did apartheid's history create this path dependence that made change so hard?
The history is everything here. Under apartheid, school funding was grotesquely unequal by design. White schools got the lion's share, or $4.3 billion for just 10% of the students, while the 85% who were black learners got massively less. Then, in the late 80s, as apartheid was starting to crumble, the old regime introduced Model C schools. These were public schools, but they relied heavily on user fees.
A way to keep control locally.
Precisely. It was a deliberate move to lock in white privilege and maintain white control over the best public schools, even after the political transition they knew was coming. These fees were crushing for black families, maybe 14% of their income, compared to just 3.5% for white families. So after 1994, the new Democratic government comes in, removes all the formal race barriers to enrollment. Great. But that user fee system, the legacy of Model C, was left in place. That's the path dependence. It was a system they inherited.
So the architecture of inequality was already built, and dismantling it had huge costs. What were the ANC's options, those switching costs?
They essentially faced two terrible options, according to Roithmeier's analysis. Option A, equalize funding upwards, getting rid of fees and funding all schools at the level of the best resourced, historically white schools. Sounds great in principle, right? True equality. But it would have required a massive hike in the national education budget from about 7% to 10.5% of GNP, practically overnight.
And the government couldn't afford that.
It flew directly in the face of their economic policy at the time, the GEAR program, which was all about fiscal austerity, controlling spending to stabilize the economy and attract foreign investment. They feared that such a huge spending increase would trigger massive flight of predominantly white capital out of the country, potentially collapsing the economy they were trying to build. That was a switching cost they felt they couldn't pay.
Wow. So the dream of educational equality clashed head-on with perceived economic survival. What was option B?
Option B, equalize downwards, get rid of fees, but fund all schools at the much lower level that historically non-white schools received. This would mean slashing funding for the privileged, historically white schools. The fear here was triggering white flight, not just capital flight, but the flight of middle and upper income families, the influential opinion makers and decision makers, abandoning the public system for private schools.
And why was that seen as so bad, apart from losing those specific families?
Because experts predicted this exodus would lead to a death spiral for public education. As influential parents leave, political support and overall public spending on education would likely plummet. They foresaw a worsening spiral of mediocrity, lack of funding, and lack of accountability, potentially leading to the collapse of the public education system altogether. Another unacceptable switching cost.
So, faced with either potential economic collapse or the collapse of the public education system, retaining the user fee system, despite its deeply unfair effects, must have seemed like the least bad option, the path of least resistance, locked in by those terrifying costs.
That's precisely Reuther's argument. The system became self-reinforcing. The health and quality of public schools got tied to keeping those wealthier, largely white families in the system. If spending drops and they leave, funding drops further, like a predicted 1% GDP fall for every 10% of students leaving. User fees became seen as the necessary evil to prevent this downward spiral. Inequality became locked in as a way to preserve the system itself.
And the result today, the inequality we actually see on the ground.
It's stark. The fee-rich schools, mostly historically white, in wealthy areas, spend far more per student, like R4178 versus maybe R23046 in a poor school. That translates directly into better resources, smaller classes, better teachers, better facilities, and unsurprisingly, much higher graduation rates. A two-tier system, effectively.
But didn't you mention an exemption system for poor families? Doesn't that fix it? Or is that another example of a neutral policy not working out?
Well, Reithmeyer argues it largely fails to bridge the gap for several reasons. First, just getting into those fee-rich schools is hard for poor black students. Soft zoning admission rules and just the geography of segregation mean they often don't live nearby. Applying across districts might put them lower on the list. And transport to schools in richer, often distant suburbs is a huge practical hurdle.
So the door might technically be open, but it's miles away and hard to get through, hidden barriers.
Exactly. Second, there are all the hidden fees: transport, uniforms, textbooks, activities, equipment. These can add up to maybe 25% on top of the official fees, and they're often not covered by exemptions. Think R500 for a basic uniform, R1100 a year for transport. These are huge sums for poor families, creating impossible barriers, even if the main fee is waived.
Okay, practical and financial hurdles. Anything else?
Yes. Third, and this is really insidious, the application process for exemptions is often described as stigmatizing and dehumanizing. Complex forms, intrusive interviews about your poverty. It can be incredibly off-putting. People might just not apply, even if eligible, to avoid the shame or hassle. We see this elsewhere. Healthcare fee waivers in Zimbabwe, for example, had very low uptake. Maybe less than 20% of eligible people actually got them. So the exemption system, despite its good intentions, doesn't effectively provide access for the poor to these better schools. The historical inequality remains locked in.
That South African example is just incredibly powerful. It shows how history, economics, and policy interact to lock in disadvantage, even without ongoing malice. Let's switch gears now, bring it closer to home for some listeners. The UK's hostile environment policies and the Windrush scandal. This feels like another major example of these dynamics playing out, right?
Absolutely. It's a critical and deeply upsetting modern example. The hostile environment that was the UK Home Office's own term was a set of policies designed deliberately to make life incredibly difficult for undocumented migrants. The idea was to make it hard to live, work, rent housing, get health care, even open a bank account, essentially forcing people to leave. And the burden of proving your legal status was pushed firmly onto the individual.
And this caught the Windrush generation in its net. Remind us who they are and why they were vulnerable, even though they were legally in the UK.
Right. The Windrush generation refers to around 600,000 people, mainly from the Caribbean, but also other Commonwealth countries, who arrived in the UK between 1948 and 1973. Many came at the invitation of the British government to help rebuild after the war. They had every legal right to be there, had lived, worked, paid taxes for decades. But the hostile environment demanded proof of status. often documentary proof going back decades. And many from that generation simply didn't have it. They might have arrived as children on their parents' passports, or the government hadn't kept proper records back then, or landing cards had been destroyed. They were being asked for documents that often didn't exist.
So they were legally resident, but couldn't prove it to the satisfaction of this new, harsh system. What happened to them?
The consequences were devastating. Hundreds were wrongly detained, some deported to countries they barely knew, people lost jobs, lost homes. One person was reportedly homeless for over a decade because of this. They were denied health care, couldn't access benefits, couldn't run businesses, lives were ruined, families separated. The stress and trauma were immense. Tragically, at least 9 people are known to have died before even receiving compensation from the scheme set up later. It was a catastrophic failure with a terrible human cost.
It sounds utterly systemic. Was it recognized as such? What did the official inquiries find?
Yes, very much so. Wendy Williams's independent review, the Windrush Lessons Learned Review, was scathing. It found institutional ignorance and thoughtlessness towards the issue of race and the history of the Windrush generation right inside the Home Office. She explicitly said this was consistent with elements of institutional racism. The review pointed to a culture of disbelief, a culture of distrust and indifference towards Black people that underpinned the policies and their implementation. It wasn't just a few errors, it was the system itself.
So, the culture and the institutional mindset led directly to these outcomes, even if individuals weren't setting out to harm this specific group initially. What about the checks and balances? Wasn't the public sector equality duty, the PSED, supposed to prevent this?
The PSED. Yes, it should have. Public bodies have a legal duty to consider how their policies affect equality. But the reviews found massive failures in how the Home Office applied it, or rather didn't apply it. Firstly, they just didn't seem to grasp the potential impact. Assessments downplayed the risks, underestimated the number of people who could be affected, and crucially, they failed to look at the cumulative impact, meaning they assessed each hostile environment measure, landlord checks, employer checks, NHS charging in isolation. They didn't step back and ask, what's the combined effect of all these policies hitting vulnerable groups simultaneously?
They missed the big picture.
Exactly. Secondly, the timing was all wrong. Equality assessments were often done after ministers had already approved the policy, sometimes even after the laws were drafted. They became tick-box exercises, not genuine tools to shape policy. Thirdly, they fundamentally misunderstood or misapplied the duty. Officials claimed the policies had no impacts on the grounds of color or national or ethnic origins because, supposedly, they affected all migrants the same way.
But that completely ignores indirect discrimination, doesn't it? The fact that some groups, like the Windrush generation, were far more likely to lack the specific documents required?
Precisely. It ignored the obvious, foreseeable disparate impact. Which leads to the fourth point, a culture problem. Reviews highlighted a narrow focus on delivering the political commitment of reducing immigration and a culture where equality was not seen as important. Getting the numbers down trumped considering the human or discriminatory cost. And finally, the burden of proof issue. Caseworkers demanded proof beyond reasonable doubt, like in a criminal trial, instead of the lower civil standard, balance of probabilities. This made it incredibly hard for people to prove their status based on decades-old events and patchy records. All these failures together created the perfect storm for the Windrush scandal.
It's a chilling example of how institutional culture, policy choices, and a failure to consider equality can combine with devastating effect. And the Windrush scandal, while horrific, probably isn't an isolated issue, is it? Let's broaden out. What do reports say about wider inequalities for Black people across the UK?
Yeah, the UK Joint Committee on Human Rights report paints a concerning picture and suggests these aren't isolated incidents, but part of a wider pattern. One really stark finding. Over 75% of Black people in the UK don't believe their human rights are equally protected compared to white people. That's a huge trust deficit.
3/4. That's a powerful statistic reflecting lived experience. Is there a sense of why things aren't improving despite lots of reports highlighting these issues over the years?
A major theme is the implementation gap. We keep having reports, Windrush, the Lamy Review on Criminal Justice, the McPherson Report after Stephen Lawrence's murder years ago, all identifying structural racial inequalities and making recommendations. But there's this repeated failure to actually implement those recommendations fully or effectively. David Lamy himself pointed out only 6 of his 35 recommendations had been acted upon years later. It suggests a systemic blockage, maybe a lack of political will, maybe just inertia. preventing known solutions from being put into practice.
So the knowledge is there, the blueprints for change exist, but the action is lagging significantly behind. Where are the inequalities most acute, according to these reports?
Health is a deeply worrying area. The maternal mortality statistic is just shocking. Black women in the UK are 5 times more likely to die in pregnancy or childbirth than white women.
5 times.
Yes. And that gap is actually widening, not closing. Reports cite institutional racism as a factor. Things like biased assumptions by healthcare staff leading to Black women's pain or concerns not being taken seriously enough. We all saw it with COVID-19. Black people had higher infection rates, a 10–50% higher risk of death compared to white Brits, and Black pregnant women were 8 times more likely to end up in hospital with COVID. It points to underlying health inequalities and potentially unequal treatment.
Those health disparities are truly frightening. What about the criminal justice system?
Mistrust is incredibly high there. 85% of Black people don't feel confident they'd be treated the same as a white person by the police. And the statistics seem to bear that out. Black people are 5 times more likely to have force used against them by police, nearly 8 times more likely to be tasered. They're massively overrepresented in prisons, making up 7.7% of prisoners, but only 3.4% of the general population in England and Wales.
That's a huge overrepresentation. Is there a term for why that might be happening on the streets?
It's often described as over-policing of Black communities. Look at stop and search rates. 38 stops per 1,000 Black people, compared to just 4 per 1,000 white people. Think of the high-profile case of the athlete Bianca Williams being handcuffed while her baby was in the car. It brings home the reality of that experience for many. Even during COVID lockdowns, Black people got fines at 1.8 times the rate of white people. And tragically, there's also a disproportionate number of Black people who die following contact with the police or in custody.
It paints a picture of deeply unequal interactions with the state, from health to justice. What about basic democratic participation?
Even there, we see a gap. Around 25% of Black voters are estimated to be unregistered, compared to an average of 17% overall. That's a significant number of voices potentially missing from the democratic process. So across the board, health, justice, democracy, and as we saw with Windrush, immigration, there's this persistent pattern of systemic inequality highlighted by these reports. It's clearly a deep-rooted challenge.
Okay, we've really unpacked a lot here. From the subtle ways neutral policies can discriminate indirectly, to these deeply locked-in systems that just keep reproducing inequality because of history and switching costs. We've seen it in South Africa's schools, the UK's hostile environment, and these wider UK disparities. But it's not just about understanding the problem, is it? It's about, okay, what do we do with this knowledge? How do we use it to push for change? What are the proposed solutions?
Right. Let's look at the pathways forward suggested by these sources. First, revisiting the legal side. The South African approach, focusing on discriminatory effect, is seen as quite potent, and Roithmer's proposed remedy for the school fees, acknowledging the lock-in, is interesting. She suggests not trying to abolish fees overnight, which might be impossible due to switching costs, but imposing a partial ceiling on them. And crucially, coupling that with redistribution, taking some funds from the fee-rich schools and redirecting them to disadvantaged ones. It's a pragmatic step, trying to chip away at inequality within the existing constraints.
A practical approach to a locked-in problem, trying to make progress without triggering those feared collapses. What about the UK recommendations dealing with those pervasive issues we discussed?
The UK reports offer a whole suite of proposals, reflecting how widespread the problems are. Top of the list, almost universally, is implement the recommendations you've already got. Close that implementation gap from Windrush, Lammy, and McPherson. Make government departments actually do what these reviews said needs doing. Accountability is key.
Stop just writing reports and start taking action. Makes sense. What else?
A more strategic approach is needed. A comprehensive cross-government race equality strategy. Not just individual departments doing their own thing, but a coordinated plan backed up by much better data collection so we can actually track progress, or lack thereof, then targeted action. Setting specific goals like, crucially, ending that shocking disparity in maternal mortality for Black women. General efforts aren't enough when specific groups face such extreme risks.
So focus resources where the harm is greatest. What about reforming the specific institutions involved, like the police and Home Office?
Yes. For policing, suggestions include regular, independent polling of Black communities about their confidence in the police, with clear targets set for improvement. Put public trust front and center. Also, actively working to recruit and retain more Black police officers to better reflect and understand the communities they serve. For the Home Office, the call is for deep cultural change, moving away from that culture of disbelief towards one based on humanity, dignity, respect. And practically, fixing the Windrush compensation scheme urgently, like lowering the unreasonable burden of proof required from victims. Make it easier for people who are wronged to actually get compensated.
Okay, institutional culture change, practical fixes. What about strengthening the democratic process and the bodies meant to protect rights?
On democracy, consulting seriously on automatic voter registration is proposed to tackle that registration gap among Black voters and ensure everyone can participate. And strengthening the Equality and Human Rights Commission, the EHRC, making sure it has Black representation at the highest levels, giving it adequate funding, and boosting its powers to investigate human rights breaches and support legal challenges. Some also suggest maybe even recreating a dedicated national body focused specifically on race equality, feeling that focus might have been diluted when it was merged into the broader EHRC. And critically, supporting independent, Black-led community organizations. They're often doing the vital work on the ground, providing support and advocacy and need resources.
It sounds like a call for fundamental shifts, really strengthening the architecture of equality, not just tinkering around the edges.
Exactly. And that includes looking at the law itself, reviewing equality legislation to make it more effective. One key idea is strengthening the specific duties under the public sector equality duty. Not just requiring public bodies to think about equality, but potentially requiring them to take concrete action when racial inequalities are identified. Making it a proactive duty to tackle disparities, not just passively consider them. These are all potential pathways aiming for real systemic change.
So let's try and wrap our heads around this. What have we really unpacked today? We've seen discrimination isn't just, someone being openly hateful. It's often subtle. Those apparently neutral policies that hit some groups way harder than others, that's indirect discrimination.
And then there's that deeper level, the locked-in systems, where historical advantages just keep rolling on because the cost of changing the system, the switching cost, seems too high.
Like we saw with the South African school fees, a direct legacy of apartheid's funding structures creating impossible choices.
Exactly.
Yeah.
And we saw how these forces play out in real lives. The Windrush generation, caught by the UK's hostile environment, the shocking health gaps, the deep mistrust in the justice system for Black communities in the UK. It's complex, it's interwoven.
But hopefully, you, listening, now have a richer vocabulary, a deeper framework for understanding why these inequalities stick around, and crucially, how to talk about it.
Yeah, that knowledge really is power. It helps you move beyond just feeling frustrated or confused toward a clearer, sharper analysis of what's actually going on beneath the surface. It's about seeing both the obvious and the hidden ways disadvantage gets perpetuated.
And the sources we've dug into today really suggest that the big fight for equality isn't only about changing individual hearts and minds, important as that is. It's also about redesigning those structures themselves, the policies, the institutions, the economic realities that keep churning out unequal results because of their subtle workings and sheer historical weight.
So the final thought to leave you with is this. Armed with this understanding, what concrete steps, maybe even small ones, can you take? How can you use this lens to identify and maybe challenge these embedded inequalities in your own world, your workplace, your community, the systems you interact with?
Maybe it's asking questions about a policy's impact. Maybe it's supporting groups working on systemic change. Maybe it's just explaining these concepts to someone else. The deep dive really continues, doesn't it, within each of us and out in the world.